Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on accountability under the GDPR. I'm going to be talking about what accountability, newly introduced in GDPR, means for boards and senior management. I'm Alan Calder. I'm the founder and executive chairman of IT Governance, and I'll be your host for today. IT Governance, as you probably already know, is an organization that deals with a very broad range of IT and GRC subjects. We're focusing very substantially at the moment around cyber resilience, cyber security, and data security, particularly with the GDPR, which comes into force across the European Union in around about 16 months' time, beginning to exercise minds in boards, managements, and of course data protection professionals very broadly right now. Our agenda today is to look very briefly at the background to GDPR. A brief cover, many of you may already know this, but what the scope of GDPR is, what the penalties that are possible under it look like when it comes into force. And then we're going to start looking at the principle of accountability, what it really means for organizations. We're going to talk a bit about how the principle is applied in reality, what that means in terms of both data privacy audits and impact assessments, the development of policies and procedures that comply with the regulation, and how that moves into issues around GDPR awareness and training, and the need to have somebody inside the organization who can deal effectively with data privacy. I'm going to spend about 35 or 40 minutes talking you through that subject matter, and at the end of it there will be 15 to 25 minutes depending on how much time you need, and we've got available to answer questions, so please do use either the chat function or the Q&A function that the software here provides to pose questions, and then do feel free to ask questions, of course, as we're going through the webinar, but I will pick all of them up and answer them as they come in at the end of the session. So, brief introduction. I said, while I recognize many of you may already know about GDPR, some of you may not yet have got around the key details. So, the starting point is the difference in European Union law between a directive and a regulation. Directives are exactly as they sound. They're a directive from the European Commission to a member state government saying you need to put in place legislation which covers the following area and does the following things. The current data protection regime across the European Union is the output of the Data Protection Directive, and as a result of it being a directive, there are differing levels of data protection law in each of the 28 member states, because there's substantial flexibility for organizations and how they go about addressing the directive, the requirements set out in the directive. A regulation, on the other hand, at the point that it becomes effective, is applicable as written in each member state, unless there are specific clauses which identify opportunity for member governments to put in place their own variations. The regulation as written applies exactly the same way across the whole of the European Union, and that means that it removes all of the areas in which member states can make substantial variations about how things happen, and that in principle brings greater certainty both for organizations and for consumers within the European Union as to how exactly a particular set of issues should be addressed. GDPR, as the acronym suggests, the General Data Protection Regulation, is a regulation, and so when it comes into play, it comes into play exactly as written in all 28 member countries of the European Union. And I'll touch in a minute on Brexit. The key issue, who does it apply to, is covered in Articles 1 through 3. It applies to natural persons, living individuals, so not people who are deceased. And the regulation says that natural persons have rights which are associated with the protection of their personal data, how it's processed, and they have an unrestricted a right to the unrestricted movement of their data within the European Union. So that's the who is within scope. The what is in scope is any personal data or personally identifiable information, sometimes abbreviated to PII, that's processed wholly or partly by automated means, or that's part of a filing system or intended to be. That pretty well means all personally identifiable information of pretty well any sort, whatever you're intending to use it, is going to fall within the scope of the regulation. It applies to both controllers and processors in the EU, irrespective of where the processing takes place. So you might be processing data in some other country outside the world. If you're based inside the EU, it applies to you, and it also applies to controllers. Controllers defined as those organizations who define the purpose for collecting, using, and whatever happens to personal data. If they're not inside the European Union, GDPR still applies very specifically to them. And I'm not going to be talking about those kind of issues, but you just need to be aware that this is a regulation whose application is global in practical terms. So, the key point is that natural persons have rights, and those rights include the right to a judicial remedy where they think their rights have been infringed. That means you can bring an action against an organization that's infringed your rights, and you can do so in your own member state or in the member state where the infringer is based. That's up to you to choose where you wish to do it, and if you've suffered damage and you can prove it, you're entitled to receive damages, and those damages under the regulation are not capped. The controller involved in processing will be liable for damages caused by the processing. So that's the first set of issues for one as an organization. You've got the potential for individuals to bring actions against you. There are costs involved in defending actions, and there are potential findings against you and awards being made against you in favor of individuals whose rights have been transgressed. On top of that, there is the possibility of administrative fines, and the administrative fines, which are intended to be, on the one hand, effective and proportionate, are on the other hand intended to be dissuasive. So dissuasive means they're intended to stop organizations doing the kinds of things they've done and to send a clear message to other organizations through the European Union that these are bad things to do. There are two levels of fine for lower levels of transgression. The maximum administrative fine is 10 million euros, or up to 2% of last year's global turnover. For major transgressions, it's up to 20 million euros, or 4% of total worldwide turnover in the preceding year, which in both cases, whichever is the higher. And you have to assume that regulators are going to use the penalties. That's why they're there. Regulators around the European Union have had a substantial input into the drafting of the regulation, and it recognizes that the compliance with data protection regulation is very variable around the EU, and one of the objectives of GDPR is to ensure that data subjects have a consistent approach to their data wherever they may be based inside the EU and wherever they may be dealing inside the European Union. So what happens if there's a breach? And this is a really critical thing, because in most countries of the European Union, there has been no legal obligation for an organization to report a breach to their regulator. In the United Kingdom, there's an administrative obligation for public sector organizations to report breaches. A personal breach, a personal data breach, is defined as any breach of security leading to accidental or unlawful destruction, loss, alteration, disclosure, access to personal data, whether it's in storage or transmission or however it's being used. So the breach of personal data must, from the point the Act has effect, be reported to the regulator, to your local regulator, without undue delay after you become aware of it. All data breaches have to be reported by a data processor to a data controller, and data controllers have to report all breaches unless they're very clear that there is no possible danger to the data of data subjects, limited circumstances which can be avoided. But if you assume that in the vast number of instances it's a legal requirement to report a data breach to your regulator within 72 hours, describing what happened and therefore why it happened, and if you can't do it within 72 hours, you've got to explain why you couldn't. So the big shift is for most organizations, certainly in the private sector, where you could hope that you could avoid a fine because unless journalism found out about the breach and you therefore in effect had your arm twisted and you had to report it to the regulator, you could hope that any breaches that you had wouldn't lead to exposure. You're now forced to expose yourself, and failing to report a breach itself will of course be yet another breach of the Act. So when it does get found out and reported that you not only had a breach but you failed to declare it, you can assume that the size of the administrative fines or penalties levied on you will be that much higher. So it's a very significant change in terms of potential impact on organizations if there is a breach, and if because not only can you get significant administrative fines, but the individuals whose data has been breached are in a position to bring an action against you. The law itself was adopted in April last year. It's been published. It technically entered into force in May 2016. It applies from May 2018. That means that there is a 2-year transition period up to May 2018, but on the 25th of May 2018, the law applies. In the United Kingdom, there are still many organizations saying, but the UK is planning to leave the European Union, so surely it won't apply. The legal reality is that in all member states, the law will come into effect on the 25th of May 2018, and the current working assumption is that Britain will still be a member of the European Union on the 25th of May 2018, so by definition, GDPR will come into force. If that weren't enough, both the Information Commissioner and the government have already confirmed that GDPR will come into force on the 25th of May 2018. The proposed Great Repeal Bill, which the government is intending to bring, will not be repealing legislation so much as putting all European Union legislation formally into the British statute books, and it will be doing that so that at some later date the British government can, as it sees fit, amend or repeal legislation. And one has to assume that given the likelihood that many organizations in Britain will want there to be an equivalence in terms of data protection status between the European Union and UK, that making significant changes to GDPR is likely to be very low down on the government's lists of priorities. So the practical planning point of departure is the GDPR will come into force on the 25th of May 2018 and will apply to all organizations in the United Kingdom from that date forward. So what does it mean? What does that mean in terms of accountabilities for boards, managements, and directors? Let's start with the rights of data subjects, as that's where GDPR itself kicks off. The requirement in Article 11.1 of GDPR is that the controller, and the controller is the organization that is determining to collect information and what will happen with that personal information once collected, it must take and the words are appropriate measures to provide any information relating to processing of that data to the data subject in a concise, transparent, intelligible, and easily accessible form in clear and plain language. So you have to be transparent and clear in any information about any processing to any data subject. More particularly in 11.2, GDPR says that the controller has to facilitate the data subject exercising his or her rights to give consent to how their data is processed, to having access to it, to being able to rectify any errors they believe exist, to have data erased if it's no longer relevant or correct, to restrict processing if there is a period during which there is a disagreement over the accuracy or otherwise of the data or the basis on which it's being processed, and the right to object to how it's being processed under certain circumstances. In addition, data subjects have the right to data portability, to be able to get given their data in a machine-readable format that's appropriate for use elsewhere. They have the right to withdraw consent at any time, and if you weren't aware of this, it has to be as easy for them to withdraw consent as it was for them to give it, which means that if you're asking them to tick a box on a website to give consent, they need to be able to tick a box on a website to withdraw consent, and that withdrawal of consent needs to be immediately effective. They have the right to lodge a complaint with the supervisory authority, and they've got the right to be informed of automated decision making as well as any particular consequences in relation to the data subject. So very significant set of rights that data subjects will have. Organizations, data processors, and particularly data controllers have an obligation, have a legal obligation to be responsible for and be able to demonstrate compliance with the requirement that they process personal data in accordance with the 6 principles of data processing. And the 6 principles, which you see listed on the screen here, are in some ways similar to the principles that were in the Data Processing Directive. These are more extensive, more clearly written, more detailed, and they start with lawful, fair, and transparent processing, collection for specified, explicit, and legitimate purposes, that the processing should be both adequate but also relevant and limited to specifically what the purpose for collecting it was. The data should be kept accurate and up to date, retained only for as long as necessary, not for as long as you might think you want to keep it, but necessary is clearly defined. And then, big one, and we'll talk about this in a bit more detail, processed in an appropriate manner to maintain security. So the controller is expected to process data to recognize the rights of data subjects, taking those 6 principles, working to those 6 principles. And the concept of accountability, the organization's accountability acting through its directors, boards, and senior managers and employees applies across all of those principles. So the principles by which data processing should be applied, and then accountability is an additional principle, not a standalone. It's a filter, if you like, which says all of these things the organization has to be able to demonstrate that it has put in place accountability processes to ensure that it actually deals with the rights of data subjects and processes information in that way. Interestingly, the United Kingdom's Information Commissioner made a speech to the Institute of Chartered Accountants of England and Wales back on Tuesday, the 17th of January, and it was a speech which was about accountability. So I've decided to pick up a couple of comments that she made because it captures very clearly the logic of what accountability is about for GDPR. She said, first of all, the new legislation creates an onus on companies to understand the risks they create for others, for data subjects, and to mitigate those risks. So she says the law requires organizations to move away from thinking of the law as simply a box-ticking exercise and instead to work on a framework that can be used to build a culture of privacy that pervades an entire organization. And you'll all be aware that changing culture is not something which can be done without clarity from board and senior management. It needs to be driven, needs to be led. It's a clear expression of accountability. The GDPR mandates organizations to put into place comprehensive, proportionate governance measures. And she goes on to say it means a change to the culture of an organization. That isn't an easy thing to do, but it's certainly true that accountability cannot be bolted on. It needs to be part of the company's overall systems approach to how it manages and processes personal data. So that's a very significant message, and it puts into some kind of perspective the 16 months between now and the 25th of May 2018, because in many organizations, if we're honest, the approach to data protection is simply a compliance tick box exercise. It's a bolt-on, and it has to become, and we'll talk a bit about the way in which it has to become part of the culture, so that the organization sees it as part of its competitive edge, part of how it behaves, part of how it acts as a corporate citizen. What do we mean when we say part of the overall systems approach? Well, the Act talks about data protection by design and by default. And I just pick up the couple of articles from the regulation which talk about what is meant by design and by default, the idea of data protection by design and by default. 24.1 says that taking into account all of the aspects of why you're processing data, as well as the risks to the rights and freedoms of your data subjects, the controller must implement, and you'll see this next phrase, appropriate technical and organizational measures. It comes up multiple times. The data controller must take appropriate technical and organizational measures to ensure and be able to demonstrate that the processing is performed in accordance with this regulation. Appropriate technical and organizational measures. It doesn't tell you in detail what those are. You have to work out for yourself what those are. It's another way in which the culture of the organization will have a huge impact on the way in which you're able to demonstrate compliance with GDPR. It goes on to say in Article 25.1 that taking account of the state of the art, which means, of course, as the state of the art changes from year to year, how you manage your processing has to continue to be updated to reflect the state of the art. But on the other hand, you can also reflect the cost of implementing technologies and processes. You can reflect the context and purposes of processing, but you also have to take into account variations in likelihood and severity in terms of impacts to the freedoms and rights of your data subjects. You've got to make sure that at the time you're determining how you're going to process data and when you're processing it itself, that again, you must implement appropriate technical and organizational measures to implement data protection principles effectively and to integrate the necessary safeguards into processing in order to meet the requirements of the regulation. So it's saying quite clearly that if you're going to process data, you need to have thought through the risks to the rights of data subjects, and all aspects of how you're processing that data need to reflect the decisions you make and implement through appropriate organizational, administrative, technical measures to ensure that that data is appropriately and correctly protected. Finally, in the next sub-article 25.2, GDPR says the controller has to implement appropriate technical and organizational measures to ensure that by default, not just, oh, hang on a minute, just remember we're supposed to that, by default, only personal data necessary for a specific purpose is processed, that you're not collecting or processing data more than is specifically required for the identified purpose that the data subject has signed up for. So that obligation applies to the amount of data you collect, the extent of the processing, how long you store it for, who can access the information, how you protect the information, how you make sure that it doesn't get made available to an indefinite number of people. So you can't simply collect information and having collected it decide that you can find additional uses for it and then use it for those things. You can't collect information from customers who buy something on a website, for instance, and having bought something from the website, you decide that although all they did was consent to your terms and conditions, that because they bought something, they might be interested in buying something else, and so you send them information about something else. That would be not something which they've consented to do. You couldn't keep the information and then a year later go back to them and say, just in case you're interested, we want to tell you about something else that we've done, because again, that's not what the data subject signed up for. So part of your overall systems approach, the way you design and build systems from where you collect data to how you process it and how you store it, has to be consistent with why you're doing it and the consent that the data subject gave to you for the doing of it. And that kind of takes us back round to the sixth principle, which, if you remember, is about appropriate security. And although the previous five principles each, in a sense, stand on their own, the sixth principle, a bit like the principle of accountability, applies across all of the PII, the personally identifiable information that you gather. The sixth principle says that you have to process data in a manner that ensures appropriate security, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage, using, again, you notice the same phrase, appropriate technical or organizational measures. What's appropriate, proportionate to the risks of that data, and when you think about how do we interpret that, the measures need to ensure that the level of security is appropriate to the nature of data. It's obviously sensitive information dealing with gender, political opinion, sexual preferences, has to be protected to a much higher level than simple information, perhaps about names, addresses, and contact information. So the protection has to be appropriate to the nature of the data and the harm that might rise from a result of breach of security. Information about passwords, obviously, if released, will bring potentially greater harm than simply lists of names and addresses. So the level of security should be appropriate to the impact of a breach of security and should take account of technological developments and costs of doing so. That means that if you're a small organization, you can't afford very expensive technology. You don't need to have very expensive technology, but you should have the technology that you can afford and that's appropriate to the risks that you're protecting against. The requirement is to take reasonable steps to ensure the reliability of employees who have access to personal data, as well as reasonable steps to ensure the level of security around the data. And that means making sure people have proper security clearances where necessary, they have appropriate training, that they're going to be reliable, they're going to deal with personal data in a way that they should. And remember, when we're talking about reliability of employees, we're not just talking about will they try and steal the information, but GDPR is about protecting integrity of information, protecting the retention of data only for specified periods. So employees also have to understand how long you're allowed to keep information for. They have to understand the processes around responding to data subject access requests, for instance. All of those are part of ensuring that the employees are able to deal appropriately with information. So that means organizations have to design security to fit the nature of the personal data that you're collecting and or processing and or holding, and you have to deal with the potential harm that would come from a security breach. You have to be clear about who has responsibility for ensuring information security with the right physical and technical security measures in place, all backed up by robust policies, procedures, and reliable, well-trained staff. And you have to be ready to respond to any breach of security swiftly and effectively. And you've got to be able to do that because bear in mind that you're almost certainly going to be breached whatever happens, and so being able to limit the extent of a breach and being able to respond to it quickly is a key part not only of protecting the data of data subjects, but also being in a position to report quickly and effectively to the regulator under circumstances where you might need to. So that's really what the principle of accountability is about. How do we apply it? What do we have to do in organizations to demonstrate that we are being accountable and that accountability is embedded in the culture of the organization? It really starts with governance. It really starts with the top management of the organization. The top management, of course, the board of directors, and whether it's a UK single tier or a continental two-tier board, it's the same principle. The officers of the company have to take the primary and first role in ensuring that personal data is appropriately dealt with through the organization. So risks to personal information should find their way onto corporate risk registers. I would say they should be on corporate risk registers now, but if they're not, they certainly want to be on there quickly. And the risks to the organization of breaches arising from data protection breaches should be on there. They're two separate categories of risk. There should, in the same way that boards will usually have a director who is nominated as being responsible for health and safety, there should be a director who's nominated as being responsible for the protection of PII, for GDPR compliance. And in fact, you can increasingly think of GDPR compliance in much the same way as you might think about health and safety compliance, health and safety at work. That in most organizations has now become embedded, part of how you design processes, how you design activities, how reporting works, how information is collected. Health and safety is just part of what you do. So in the same way, GDPR has to become just part of what you do. So a nominated responsible director, clear roles and responsibilities allocated through the organization for data protection, and in particular, whether you have a DPO or not, and we'll touch on DPOs a bit later on, somebody needs to have the functional responsibility for dealing with GDPR, not just compliance, but the embedding of it in the organization. And again, I'd make the parallel between how most organizations deal with health and safety or HR. Most organizations, even relatively small ones, will have somebody who deals with HR perhaps on a part-time basis, perhaps contracted in from outside the organization, or in slightly larger organizations, medium-sized organizations, there will be a full or part or full-time member of staff or even a team dealing with HR. It's a complex area, it requires particular skills, and managing people is part of the culture of the business, the same way GDPR needs to have somebody who can deal with GDPR compliance and ensuring it's embedded in the culture of the organization. So clear roles and responsibilities, and somebody with a functional responsibility for GDPR. You should be thinking about what we'd call a privacy compliance framework. And a privacy compliance framework is a collection of a number of components. Obviously, it starts with recognition of board accountability and roles and responsibilities through the organization, but it would have something like a PIMS, which is not a British drink, it's a personal information management system working as part of or alongside an information security management system. It would have some form of incident response process which is properly developed, tested, known to be effective. You can respond quickly to identified occurrences. We've long said, and the Information Commissioner said the same thing on the 17th of January, that Cyber Essentials, which is a UK government scheme designed to deal with low levels of cyber vulnerabilities, should be seen pretty well as a standard basic starting point for organizations in terms of ensuring that they are able to deal with the most obvious ways of attack. And I'll talk a little bit more about Cyber Essentials in a minute. Certification and data seals. Article 42 of GDPR introduces the idea that organizations can turn to independent accredited certification to appropriate national and international standards as a way of demonstrating that they've taken appropriate organizational, administrative and technical measures to meet their obligations to protect personal data and to apply proportionate security measures. And at the moment, the only recognized international standard, the only international standard that deals with information security management is ISO 27001, already a very widely used standard around the world for information security. It's likely that there will be one or more data protection seals developed and launched over the course of the next 1 to 3 years in different jurisdictions or perhaps in different sectors, which are likely to have very specific sets of requirements and independent audits against them. GDPR sets out a framework within which those can be launched, which would make it possible for organizations to demonstrate and be audited as complying with specific codes of conduct or specific sets of rules, and demonstrating that they're complying with GDPR. And from an accountability point of view, all organizations should be thinking about, given that we're likely to be breached, given that we're likely to have some sort of problem at some point, we need to make sure that we can demonstrate that we did what we should have done, that we were not negligent, that we met our fiduciary duties to protect the information of the data subjects we've collected, to apply the principles of GDPR, to reflect the rights of data subjects, and being able to demonstrate the outcomes of repeated external audits against independent frameworks like Cyber Essentials, ISO 27001 and other standards as and when they emerge is a very useful way for boards to demonstrate that they're stepping up to meet the accountability requirements so clearly imposed on them. Then, of course, data protection by design and default, which I talked about earlier on, and which we're going to have a slightly closer look at shortly. And that's really expressed very much in the form of data flow audits, data protection impact assessments, finding out what personally identifiable information you've got, what happens to it, how it's dealt with, who has access to it, and what the impacts might be if the data is compromised. Of course, DPIA, data protection impact assessments, are mandatory for some types of organizations, public sector organizations, organizations processing large volumes of personal data, for instance. And for those organizations, there are very specific legal requirements around how DPIAs should be carried out. And of course, those legal requirements actually form part of good practice around DPIAs. So if you're doing DPIAs, and most organizations to one extent or another should, you'll be doing something which you might expect to meet the requirements of the GDPR. So I mentioned Cyber Essentials. Cyber Essentials is a scheme put together by the UK government, but we're increasingly seeing organizations outside the UK getting themselves Cyber Essentials certified, quite often because they want to provide services, for instance, to the UK's National Health Service, where Cyber Essentials certification is a basic requirement. You're dealing with personally identifiable information, so that's logical. And it's a set of 5 basic controls that an organization has to put in place to demonstrate that they've dealt with the key areas of potential vulnerability. It's a self-assessment process, essentially. If you're going to do Cyber Essentials, you want to find an organization which offers a self-assessment portal where you can log on, you can upload your own information, you can work your way through it. There's an attestation of compliance. And then in CREST Accredited, which is the leading format of Cyber Essentials certification, you would have an external vulnerability scan which would confirm that as an organization, what you've attested as being the case actually is the case. And for small and medium organizations, the kind of default smaller size, you shouldn't expect to be paying much more than perhaps £300 on an annual basis to be able to have a externally validated Cyber Essentials certification. So you should think of, frankly, Cyber Essentials as a basic starting point for demonstrating as an organization that you've stepped up to your accountability requirements in terms of appropriate technical measures to protect the information of data subjects. I said then we'd be talking a bit about data flow audits. Here is a fairly nice diagram which came from a book called Agile Model-Driven Development, and it's an example of what a fairly simple data flow audit might look like. The point is that if you're collecting data about individuals inside your organization, you're likely to be collecting it in a number of places. A number of people will deal with it. It'll go through a number of different stages as you process the data. It will end up being stored somewhere. And you need to know what's happening to it in order to work out where it might be exposed, where the risks are, and to make sure that it's being dealt with in a way that is in line with the obligations which you accepted when you took it on. So a data flow audit, that might start with a data inventory. What data have we got? Where do we hold it? But you'd be looking at what information is collected, what permissions did we get at the time, who is it passed to, what changes in the data, how is it held, in what databases is it held. And a data flow audit for even a reasonably small organization can be quite a time-consuming exercise. It's worth doing right because, of course, it means that you identify where data is dealt with and gives you time to work out appropriate ways to manage the security of that data and to ensure that you're not in non-compliance with GDPR. Yes, of course, you have one record which is not in compliance. That's unlikely to land you in a lot of trouble unless there's one individual who discovers it and who decides that they want to bring an action against you. But broadly speaking, if you've got processes in place which are in line with GDPR, you've identified how data should be dealt with and you're dealing with it appropriately, you're going to have got yourself out of trouble over the long run. You can't really do a data protection impact assessment without having done a data flow audit. The prerequisite for assessing impacts on the privacy of individuals of the data collected is knowing where the data is. What format did we collect it in? Is it mobile data? Is it paper data? How does the data get transformed? Who has access to it? Where is it stored? All of those things, the things that you identify as part of the data flow audit, you need to get clear in terms of being able to DPIA. And the European Union has its own DPIA template. There are 8 logical steps through it, and the working out why you need to conduct it, getting it kicked off, putting a team in place, identifying the processing of data, the data flow audit, and then risks and doing the risk assessment. That core bit of activity is much the same type of risk assessment activity that ISO 27005, the Information Security Risk Assessment Standard, sets out how to do. So you're looking at likelihoods and impacts if a threat exploits a vulnerability in relation to particular personal information. And that then leads to the selection of specific controls to reduce likelihood or impact, and then runs through into a report, and you can then review and maintain the outcome. So DPIA and staff competent and able to carry it out and maintain it become as important a part of creating an effective privacy compliance framework as does top management commitment. So in the same way as an organization thinks about a financial compliance framework, how do we ensure that the way we collect, process, store, manage money meets the requirements of law, of our audit requirements, of our financial partners, of our customers, all that kind of stuff. You're looking to create a GDPR policy privacy compliance framework which ensures that the 6 privacy principles are reflected in detail inside the way the organization develops its policies and procedures. And developing policies and procedures is a significant activity. Unless you already have a substantial suite of appropriate policies in place, you may have a very big piece of work on your hands in order to address that. The starting point is going to be a data protection policy. That's a requirement of GDPR that you have a data protection policy signed off by top board. It's an expression of the board's recognition and acceptance of its accountability under GDPR. And that then needs to flow through into a framework or a body of documentation that deals with everything from audits and compliance all the way through to how you manage retention, how you dispose of data, how you dispose of the hardware on which data might have been recorded. So all of those key parts of the policies and procedures that you need to have in place. A strong reflection of the appropriate technical and organizational measures. And developing policies and procedures like that typically involves the privacy team working with line managers and other functional managers. You might use pre-written templates to simplify your documentation writing approach, but however you tackle it, what you're looking for is a comprehensive suite of policies and procedures that you can roll out to staff and make part of your staff training and awareness activity. You want staff across the organization as a whole, particularly staff who are dealing with personal information, and that includes obviously staff dealing with customers in on the shop floor, on websites, in surgeries, wherever you're dealing with staff, you're collecting information. So appropriate technical and organizational measures means all of the staff who are dealing with personal information being appropriately trained, both in terms of general awareness of what GDPR requires, the principles, the rights of natural people, and then where people have specific GDPR responsibilities, appropriate training. So data protection officers, for instance, they need to have specific training. Those in marketing teams who are responsible for putting together mailing lists and collecting information on websites or from customers in retail or other environments need to be aware of what are the limitations, what can they do, what they can't do. So levels of appropriate, more detailed training over and above basic data protection training is a logical part of implementing appropriate administrative, technical and organizational measures. In particular, as I said earlier, a dedicated data privacy team or a DPO. There are certainly a number of organizations where a DPO is mandatory, larger organizations, public organizations, organizations processing very large amounts of data, particularly sensitive data. But good practice will lead most organizations to have somebody in the role of data protection. It has to be functionally owned by somebody. Board management and staff need continual access to that knowledge, and that knowledge is specialist. You need to have ongoing knowledge. The GDPR itself is a very substantial document. There are a number of areas. They're all minor, but they're detailed, where individual member states have room to set their own rules about what will happen, and you need somebody who can give you guidance as a board and as a management on how to deal with that broad range of issues. Above all, if and when you're breached, you need to have somebody who's going to manage your breach response, who keeps your breach response under review, keeps it flexible, makes sure it's operating effectively. Do you need a data protection officer? Well, you know, the kind of questions from an accountability point of view of who is responsible for information security, who's responsible for ensuring that as an organization you meet your legal, regulatory and GDPR obligations, who's going to provide oversight of how you go about doing that, who's going to make sure that your contracts with data processors, could be a payroll company, could be a supplier who is drop shipping products to customers, who's going to make sure that those contracts meet requirements of GDPR and that your processors or subcontractors and your supply chain meets its obligations. Who's going to manage privacy risks? How are you going to ensure that data protection becomes part of the culture of the organization? Article 37 of GDPR does say in a number of situations a DPO is mandatory, but it's in practical sense logical for all organizations to have a DPO. If you have to appoint a DPO, and you know, as I said, I think if you just rely on have to or don't have to, you're missing the point about accountability. You can have a single DPO across a group of companies. You can have a single DPO working for a number of authorities in the public sector. You can have a DPO representing particular categories of controllers or processors. Could be service delivered on the basis of a service contract. However you do it, there's any number of ways that you can do it in exactly the same way as there are any number of ways you can ensure you have appropriate health and safety representation and support, appropriate HR support. Where you do have a DPO, though, of course, there are some particular components of the role, which includes that you can't just fire them because you don't like their advice. They do have to have a level of protection built into that. They do need to have not just practical knowledge of the legal requirements of GDPR, but also good, effective knowledge of information security and skills around that, given that GDPR is about protecting data, and protecting data is about the way in which you roll out information security measures, appropriate technical and organizational measures. That means they've got to know how to deliver confidentiality, integrity, and availability within a business management framework. They've got to understand how to do risk assessments so that the controls that you put in place are proportionate to the risks that you're dealing with. Of course, they've got to be able to understand appropriate codes, standards. They need to be able to do internal audits and manage internal audits. They're likely to be the communication front of the operational aspects of the organization's approach to privacy. Above all, they're going to deal with breach response, and they'll lead any cooperation necessary with the regulator. You want to have DPOs sitting outside of IT or the business. It's a specialist function. You don't want to make data protection officers subject to people who might want to get round the requirements of GDPR. Building GDPR into the fabric of the organization means putting somebody who understands the regulation, who's committed to it and fired up to it, in a position where they can provide real independent insights, support, advice, guidance to everybody inside the organization. So typically, DPO will sit within a risk compliance or governance function, usually with direct access to the board, or at the very least, direct access to the board member who is accountable on behalf of the board for GDPR. Data protection should be on the board agenda on a regular basis, monthly or quarterly as the case may be, and needs to have the functional skills, not just the legal skills, but the functional skills. And usually a good DPO will have good legal understanding, good functional, practical business operational experience, and usually will know how to work effectively with the legal advisors to the business who provide such a key part of the overall framework. So the Information Commissioner said that accountability, of course, requires an upfront investment in the fundamentals of doing privacy properly. But she went on to say it offers a payoff down the line, not just in better legal compliance, but from a competitive edge point of view. And she's speaking from the perspective of somebody who was deeply involved in data protection in Canada. Canada, in developing its data protection legislation, went down the route of data protection by design and by default, accountability part of the culture. So she's talking from the experience of many years of driving that type of an approach into organizations. She's not just saying this is what she hopes will happen. She believes there's an opportunity for organizations to present themselves on the basis of how they respect the privacy of individuals. And many of you will have seen the data which suggests that most individuals believe that nobody cares about their data. And so organizations who do care and who can demonstrate that they do care can position themselves in a way to win substantially with consumers. So that's the carrot, she says, for getting it right, and she makes the point there's a pretty big stick. GDPR increases regulatory providers. She makes the point that they have the power to fine companies up to 20 million euros. In an ideal world, she says, we wouldn't need to use those sticks, but policymakers are clear that breaches are a serious matter. In the UK, where the current power to levy fines is extremely limited and the mechanism for levying fines is ponderous, they issued more than £1 million in fines for Data Protection Act breaches, bearing in mind that there's no obligation on private sector companies to report their breaches. That comes up. So ICO says very clearly, we're not afraid to use the powers we've got. And they're going to enforce not just typical data breaches like laptops left on trains or information left open to cyber attack or inadequate protection on websites or of internet connections. she makes the point GDPR gives regulators the power to enforce in the context of accountability. In other words, if you fail around the ideas of data protection by design, you don't do data protection impact assessments, you don't have DPOs, you don't have appropriate documentation, you're likely to find yourself in trouble, because the regulators now have very clearly the right and expectation that they will be visiting organizations, they will be making sure that organizations are compliant, not simply responding when there are breaches, but their regulatory activity will be proactive. So where organizations, she's saying, are not embracing the idea of data protection by design, by default, not embracing the idea of accountability bolted into the organization, they're leaving themselves open to fines and other enforcement managers that, as she says, will damage potentially a bank balance and or business reputation and or both. So very clear final message: accountability is a key part of how organizations respond to GDPR, and accountability and the recognition of accountability is a key part of how organizations go about making sure that the culture of the organization shifts and changes so that data protection becomes embedded. There are a number of ways in which organizations can help themselves in doing that, of course. There are both foundation and practitioner training courses that you can access, which, and I know that IT governance is already the global market leader in terms of delivering qualifications. Accredited foundation and practitioner qualifications can be accessed both in classrooms, both live and live online. There is distance learning versions of those same courses available. There are books, there are pocket guides, there's an implementation manual, and there's a pre-written set of templates in the documentation toolkit. So there are a number of tools already available on the market that organizations can use to help themselves to address GDPR. And of course, for many organizations, the speed with which you know you need to address this and the impact on systems and system changes and planning for system changes is quite considerable, might lead to the view that you want to draw in external consultancy support. We are a company, IT Governance is a company that is able to deliver that type of support, from simple gap analysis, high-level gap analysis, through data flow audits, doing data protection impact assessments, helping you implement management systems. All of those kinds of areas are areas in which, as a company, IT Governance is able to help organizations address GDPR compliance. Our own view is that by probably autumn of 2017, the only option open for companies that haven't yet started on their GDPR compliance route will be a self-help option, because there are not enough consultants available in the world to handle the volume of organizations that have to make the compliance journey. So the get started early message is a very good one. Don't delay another 3 months or 4 months. Don't wait to see if anything will change. Get started on GDPR compliance right now, because you know, the business of changing how you behave, changing culture, is going to be time consuming, and the day on which GDPR comes into force is the day on which fines can first be levied. So don't, on the 25th of May 2018, say, well, it's come into force today, we should start our compliance conversion program at that point, because at that point you are already exposed. You've had 2 years to deal with the transition from Data Protection Directive to GDPR. 25th of May 2018 is the by when you need to do it, and you don't want to waste any time in preparing for it. And that brings me, ladies and gentlemen, to an end of what I had prepared to say. We have some time left available to deal with questions from anybody who has particular questions. So if you would like to use the question function to ask questions, what I'll do is I'll pick up and read out questions and then provide answers to them. One of the most common questions that comes up is there a set of the slides available? The answer is yes. I believe we'll send out to everybody who's been on the course a link which enables them to access the access the slides afterwards. There's a so that should make that that simple. I'm not going to answer that one more often than that. So let me start picking up some of the questions, and there are a very substantial number of questions which have already come in. I have to say I can't promise that we will manage to deal with every single one of them. I'm just busy scrolling up. Timings of keeping of personal data. So how long can you keep data? Only as long as necessary. You have to work out what is necessary. There are a number of aspects to what is necessary written into GDPR as being the criteria by which you decide. But you have to decide, and it will link very clearly back to the terms on which you collected the information. So there's no simple answer. There are a combination of external requirements, like you have to keep records of VAT transactions for a given period of time, so that will require you to keep personal information for that period of time, and there will be other requirements. So part of determining the right length of time for retaining data will involve working your way through, for every category of information you've got, what a correct retention period is appropriate. Is it acceptable to have the information security manager as the DPO as well? It's potentially the case. It depends on who the information security manager reports to. If the information security manager is outside of the business, so in other words doesn't report to IT or finance, then yes, I'd say that works quite well. But if the DPO reports to the information security manager, who reports to the finance director or reports to the CIO, I would say no, that's probably not sensible, because it would make DPO subject to somebody who might not want to follow the requirements. And you want DPO's advice to be as independent as you possibly can. As are GDPR consulting roles being advertised now, and where can one find them? Well, I'll tell you right now that GDPR consulting roles are being advertised on the IT governance website. Our GDPR consulting business is growing so fast that we'd be happy to talk to GDPR consultants every single day of the week. But otherwise, you simply have to go through normal recruitment processes to look elsewhere for where people might be recruiting. Are IT governance hiring? Yes. Our organization is expected to be compliant from day one in May 2018. Yes is the answer. As I was saying earlier, the transition period is from May 2016, when GDPR technically came into force, through until the 25th of May 2018, which is when it applies or is effective from. So as I said, don't think you can get to May 2018 and start your compliance journey then. That's the date on which you need to be compliant. If I was the Information Commissioner, frankly, I'd be looking for an opportunity to levy an administrative fine against somebody on the 26th of May, just to make the point that you needed also to have been got yourself compliant by then. Are processes outside the EEA required to be compliant in the same way as a processor inside? Yes is the answer. You as a controller are responsible for ensuring that processes are compliant, but processes are also themselves subject to the requirements of GDPR, and both controllers and processes operating outside the European Union have to have representatives inside it, and if there are breaches, they are they're jointly and severally liable for the consequences of that. Any guidelines regarding which medium should be used to notify data subjects for data breach? Those will emerge. The GDPR basically says that if there's a data breach, you need to inform data subjects as fast as you possibly can. That might mean by telephone or email. It does make a provision that if there are very large numbers of data subjects where individual contact might not be practical in time, that using press advertising or internet advertising or other mediums might be acceptable. But under those circumstances, you would almost certainly be agreeing on how you respond to the breach with your regulator. Remember, the requirement is that you report the breach to the regulator, so your regulator will be talking to you and giving you potentially direction about what you must and mustn't do in terms of dealing with that breach. slides from the ICO conference. So those of you who want slides from the ICO conference, I think if you just type into Google something like GDPR, ICO, ICAEW, it should take you fairly instantly to the conference. I'll ask our marketing people, who I know are paying attention right now, to see if we can insert the link to the ICO, ICAEW presentation into that particular slide on the presentation before we send it out. So it will be on the slides if you get them. Can the information be the IT manager? I think I've pretty well answered that. Can you describe the expectation in terms of legacy information? Yes. So GDPR doesn't distinguish between legacy information and the information you collect after the 25th of May 2018. It doesn't suggest that data subjects have different rights before and after the 25th of May. They have rights. So you need to have dealt with legacy information such that on the 25th of May 2018, all of the information you hold is held in a way that's appropriate. Now, that is likely to mean for many organizations that you have substantial quantities of data to delete or archive or otherwise remove. It's likely to mean that you may have to go back to many data subjects and say, excuse me, we took your data for this reason, we're using it for that, can we please have your permission to do so? But all of those are part of getting yourself into compliance. This remaining 16-month period isn't just a period during which you change your paperwork, it's a period during which you make sure that as an organization you are compliant in all aspects of your holding and processing of data. So yes, I would say you've got to make sure you review and deal with any data that you've got. What impact will GDPR have on email in general and in specifically the rights to be forgotten? Do data controllers have to review systems and remove all mention of individual where PII is present? I think the answer to that, you've got to remember GDPR is a law, so for a number of years there will be legal cases about exactly what some of the words and provisions of GDPR means. Many of them will be argued over through either the UK Supreme Court, if that's how the UK ends up, but many of them in the ECJ. And so the rights to be forgotten, that's primarily dealing with the rights to have information removed from a public environment where it's no longer relevant, but it also clearly implies internally. And yes, if it's taken to a detailed degree, you should identify every area where you hold data and remove it. There is the component of reasonable, what's technically possible, bearing in mind the state of the art. And so there may be things which technically are not possible or not affordable for some organizations, and where there are breaches, the GDPR, the regulator will be looking for reasonable and proportionate efforts to deal with it. So there are quite a lot of detailed areas in GDPR where, in our view, and I stress it's in our view, we're not the regulator, in our view, the defense of we did what was proportionate, appropriate, we were accountable for what we did. We could only do what we could afford to do. We've taken appropriate steps to mitigate risks that remain, will be adequate arguments. What level of detail is necessary to demonstrate detail in terms of compliance instructions to employees if the company does not use an ISO standard? Whether you use an ISO standard or not, the message is still the same, which is that you need your instructions to employees to be clear and transparent. Employees need to understand what it is that they're required to do. They need to have training to enable them to do it, and they need to have their behaviors monitored to ensure that they do it. And as long as you as an organization are able to demonstrate that those aspects of staff communication and management are in place, you will have done what is necessary to ensure that staff are doing what they should be doing. Could we provide some detail on the requirement to have a record of data processing activities? How detailed should this be? GDPR sets out a number of steps that you have to retain. We're expecting individual regulators to provide more clarity about what that looks like, but in principle, if you think about the type of information that in the UK you're currently providing to the Information Commissioner as part of your annual license, while on the one hand you won't have to have an annual license anymore after May 2018, that's the type of data that's worth thinking about collecting as part of your record of data processing activities. It's fairly generic, but it covers clearly all of the data that you're doing. Do existing contractual rights override the new GDPR rules? For example, if a customer consented to having their data for the purpose we request and then attempted to use the new legislation to remove this, could you refer to the original agreement and suggest that is what you agreed to at the time? And the answer is it depends. It depends very much on what they agreed to. It depends very much on the intersection between what they agreed to at the time and the way in which the processing is still necessary for you to deliver on the contract that was entered into, but I would suggest you treat each of those on the merits of each and every case. I wouldn't think that there's any basis on which you can find a yes, you've already agreed to it, therefore it always applies basis. You have to assume that the change in law means that each of the existing relationships has to be reviewed and reconsidered. Do you need individual privacy policy or processing activities or per group of data subjects? It's going to depend very much on who's involved in what processing. You're going to have to make the decisions on that on the basis of your own privacy compliance framework. Do you need a technology solution to build your data protection maps? Not necessarily. A technology solution, a data flow audit tool, for instance, can simplify the process of doing a data flow audit substantially, make it much quicker and easier than trying to work out how to do it yourself using post-it notes. So if you can afford it, it's a practical way of dealing with it. There is no CPE component for this webinar, I'm afraid. The EU-US Privacy Shield is how you comply with the current Data Protection Directive. The Privacy Shield will need to be updated to take GDPR into account. It hasn't yet been updated, so if you are a Privacy Shield certificatee, you need to ensure that you are changing your systems and preparing for GDPR so that when the Privacy Shield itself is updated, you can demonstrate compliance with it. Yes, if you're in the European Union and you're processing the data for non-European Union national, GDPR applies to you. The DPO doesn't have to be located in the European Union. It would be odd if he or she wasn't, as the DPO has to be able to deal with the data of European Union subjects, and if the DPO is outside the European Union, you'd have to have in place a set of binding corporate rules or other protections to enable data to move outside the European Union. Of course, it's technically possible. Does the GDPR Foundation course we've offered cover all of this? It covers it at a foundational level. The practitioner course, which is a 4-day course, covers it in practitioner level, very much more implementation focused. GDPR law is that all countries must comply exactly as written, or is there flexibility? You have to comply as written unless GDPR provides for flexibility. Folks, I'm afraid we're kind of well out of time. We've had hundreds of questions. There are not yet any specific GDPR compliance certifications I think I'll take as the last questions. There is, however, ISO 27001 and Cyber Essentials, which are both certifications that indicate you've taken appropriate and proportionate information security steps to protect and preserve the confidentiality, integrity, and availability of the information of natural persons. So, folks, I'm afraid I've got to draw that to a close. Many of you have already dropped out. You won't notice that you've dropped out if you've dropped out. So I'd just like to finish up by saying thank you all for being here. There is an ongoing series of webinars. On the one hand, there is a series of webinars for those who are coming new to GDPR, which will be a repeating rolling series of webinars just looking at first steps around GDPR kicking off at the end of January, and then there will be a series of more focused webinars dealing with specific aspects of GDPR compliance running on a regular basis. And you can access all of that information through our website. So, ladies and gentlemen, thank you all for being here. I wish you a good afternoon, good evening, and look forward, if you find that we can provide support and assistance to you in your GDPR journey at any stage, to being able to do that. Thank you all.